met, I'm Mary Ellen Fullerton. I'm the interim dean of Brooklyn Law School, and it's my great pleasure to welcome you tonight to this CUBE event, the Brooklyn Law School Center for Urban Business Entrepreneurship. See how that rolls off my tongue, John? I find it a mouthful. Is putting on a very interesting panel, and I don't need to tell you because you're here to see it. But what I want to take a moment to tout is the presence we have of BLS alums. We have two members of the class of 13 with us tonight, Andrew Rauza. If you would raise your hand, and then Anna Rudowski. Anna, you're here? And I understand, Farah, you're from the class of 2012. And then our really, really special guest tonight is Bob Manny from the class of 1977. So Bob's in the back row, and let's give him a hand. And not just because he's a long-lived alum, but because he's our entrepreneur in residence. And we're so happy to have him play such an active role both this year and in past years, and I trust in future years, because as many of you know, he's the general counsel and senior vice president of Ultimate Software, which is a human capital management and benefits company rated as one of the best places to work in the United States. So to have him with his personal experience, post-Brooklyn Law School, as an entrepreneur and also as a lawyer, being involved with our students, meeting with them, going to competitions with them, and now being an entrepreneur in residence is just a kind of innovative thing that we expect from CUBE, and we're so happy to have it take fruit. So tonight's panel is another example of how CUBE does interesting programming and really tries to look at law in the changing economy. We're going to hear about a new trend, in-house attorneys becoming involved with product development in an early stage, maybe even at inception. This shift speaks to, I think, an expansion of the scope of legal services. We're going to have an engaging discussion about this new frontier for job opportunities and for the way law intersects with business, with entrepreneurship, and with really the new society that's emerging in the United States. So thank you for coming. Thank you for being part of our CUBE events. I hope you'll come to future CUBE events. Please stay afterwards for a reception, and I'm going to have John Rudikoff, the CEO of the CUBE program, now come up and give you more details about each of the panelists. Here we go, John. Thank you.
Well, thank you, everyone, for coming tonight. I'm not actually going to go through and introduce each of the panelists, but I am going to thank them for being here. On your seat, you will find bios of each of our panelists, and we're incredibly appreciative that they're here with us. I want to welcome all of you, alumni and students. I want to thank Mary Ellen for her introduction. I want to thank the CUBE faculty for being here with us and for all of their efforts. I especially want to thank Drew and Jonathan for envisioning and developing this panel. I think it's an important one, and I think we all stand to learn a lot. A common theme that we talk about at CUBE, and that we try to impart to the students that we work with, is this notion of market pioneering in legal practice. Now, market pioneering in the practice of law, from our perspective, speaks to moving upstream to find the clients of the future. Now, this is often completed through pro bono or clinical practice, and it's an opportunity for us to do good as attorneys while also cultivating our future clients and partners. Now, we talk about this a lot because we believe doing so ensures the sustainability and continued relevance of our profession. And we care about this not only because we see it as a moral imperative, that is, that every person that needs legal services receives excellent legal services, whether they can afford to pay for those services or not. But we also think it's a smart business strategy. It promises and provides us with the clients of the future. And that's an imperative for our profession. Another aspect of this strategy that we must consider as lawyers is how do we define the scope of our practice or the scope of our services? That is, at what point in the development of a new product or in the launch of a new initiative do we as lawyers become involved? Are we satisfied as a profession to be relegated as gatekeepers to new technology? Do we think it's an appropriate role for our skill set to be a check-the-box capacity at any corporation or organization? No, of course not. And new legal issues and new business models have demanded that we throw out these traditional roles, or that we at least throw them on their head. As you will hear from our moderator and our panelists tonight, lawyers by design are increasingly becoming involved earlier in the development process of any new initiative or innovation at corporations and organizations. Sometimes, as Mary Ellen said, even from the point of inception. This is an important shift. I'm excited to learn more about it, and I'm excited to hear about it from our panelists. So thank you, Drew. Take it away.
Good evening, everyone. How's everybody doing tonight? My name is Andrew Rouse. I'm a Brooklyn Law School graduate and currently work at Facebook as lead product counsel. And one of the products that I counsel on at Facebook is known as the Facebook platform. And the Facebook platform is a set of services and tools that allows third-party developers like a Spotify or a Tinder to create their own applications and services and then leverage data through Facebook. Facebook platform was also the product that was at the heart of the Cambridge Analytica incident. When the Cambridge Analytica story first broke, lawyers were on the front line of responding. But no one was looking for the traditional legal analysis that you think of when you think of lawyers. No one was asking about offer and acceptance. No one was asking whose property the fox was on. No one was asking whether the Erie Doctrine applied, which is a good thing because I didn't do well in any of those classes. What people were looking for instead were lawyers who could bridge the gap between the technical and the legal. Lawyers who had enough fluency in how the products actually worked that they could do things like mapping the data flows and understanding user privacy settings. When people ask me what industry I'm in, I say tech. I say tech because I work out of a company based out of Silicon Valley, and our primary product offering is mobile applications. But anybody really that counsels corporate clients is in tech. That's because technology and data has permeated all industries, whether we're talking about retail, CPG, manufacturing, healthcare, even government. Technology and data is involved. Lawyers have been historically slow to adapt technology, which is both a threat and an opportunity for those in this room. Attorneys who refuse to develop a basic technical fluency will find themselves unable to effectively mitigate risk for their clients. After all, how can you find ways to insulate your clients from risk if you don't really understand how their business works? Clients of those attorneys will take their business elsewhere, to tech-savvy lawyers who can speak their client's language, lawyers like those who come from Jonathan Askin's Blip clinic. In addition to bringing in business, those lawyers will find themselves exerting major influence over laws and regulations across the globe. In fact, they may do nearly as much to shape the law as the lawmakers themselves. Consider the General Data Protection Regulation, the GDPR, that came into effect in the European Union this May. Perhaps the most influential privacy legislation in decades, if not ever. The GDPR was crafted to apply to 27 member states of the European Union. Each of those member states has a vastly different history that shapes their cultural norms, fears, and values. For instance, in several Scandinavian countries, the staunch desire to improve social welfare creates an environment where people are happy to use personal data broadly for utilitarian ends. In contrast, in Germany, the history of the Third Reich using personal data for nefarious purposes during the Holocaust looms large and leads to an unyielding norm to lock down personal data unless this use is absolutely necessary. So how then is it feasible to apply one set of standards to these two starkly different places? To attempt to apply a singular regulation across such different cultures, lawmakers drafted in the GDPR a law that applies broad principles. These broad principles become the responsibility of regulators to enforce. But regulators can't do that in a vacuum. In order to strike the balance between protecting the fundamental interests of citizens without unduly burdening legitimate business activity, regulators need to work with companies to understand their business and how the technology that underlies their business actually works. They need to work with attorneys who can bridge the gap between the technical and the legal. And in this communication, tech-savvy attorneys will play a material role in shaping enforcement of these laws around the world. In addition to this work being extremely impactful, product counseling allows for lawyers to exhibit something that most consider alien to the legal field: creativity. Legal work, such as commercial negotiations, are often zero-sum. What you get, I lose. Product counseling, on the other hand, puts attorneys in the role of creator. The concept of privacy by design is the notion that you can optimize results if you embed privacy into the design and architecture of products and systems, rather than bolting it on later as a clunky afterthought. To implement privacy by design, companies like the one I work for have embedded attorneys in the product design process from the earliest stages, working with engineers and product managers to build products from the ground up. Through this process, attorneys can go beyond rote black letter analysis and apply their knowledge of regulatory frameworks to tasks like designing user experiences. Lawyers can become creators. What I've talked about thus far is the what and the why, but today you have the opportunity to hear about the how. We have for you a distinguished group of panelists who have a wealth of experience counseling clients across industries. So with no further ado, let's introduce you to those panelists. Farah, would you like to start?
Sure. So my name is Farah Zaman. I graduated from Brooklyn Law School in 2012. After graduating, I started my career actually with local government in the Department of Social Services here at New York City, and there's a dedicated team of privacy attorneys. So a lot of the focus was related to HIPAA and high tech and healthcare in that space, but it was general counseling on all data governance at the organization. One of the things that was interesting there is, given that the data set and how large Department of Social Services is there's a lot of requests to use that data for research, for outreach, for different initiatives. So part of my function there was actually reviewing those requests, reviewing the consents, and seeing how that data could be accessed and used. From there, I went on to join Nielsen, the global market research firm, and was part of a global legal privacy team that counseled around the world in over 200 countries, again on end-to-end data governance. So anything from incidents to product development to contract negotiations. And then most recently, I now lead data privacy at Colgate-Palmolive globally. I think a lot of people think of Colgate as toothpaste and don't really understand how that could be considered a tech space or area. But really, every company now is active in the data economy, whether it's from their marketing strategies to actually developing IoT devices, which Colgate does have a connected toothbrush as of this year. There's a large variety of work, and I think the other nice thing working in-house is you encounter things in other countries. So one of the issues is there's a lot of data privacy issues in relation to employees, and when we're talking about product counseling, HR teams invest immense amounts of money in technologies and resources to improve their own workforce, and there are, of course, governance issues there as well.
Great. Andy?
Andy Roth. I went to Fordham Law, right nearby, a very long time ago, so we don't need to date me, but I came out, I went to Waugatcho. I became interested in privacy because I believe that privacy is a fundamental human right. And so I think that I was drawn to the space in a different way, potentially, than other folks. And that caused some conflict for me. Later, I became Chief Privacy Officer of American Express and became very focused on trying to build a company that would provide free software that protects civil liberties. And so I decided to go back to law and, as a side hustle, launch privacy.com, which raised funding from a pretty big VC and is doing pretty well. And I stepped down from that about a year ago. And so I'm currently a partner at Cooley, and I focus on privacy, security. I should say also I got involved in blockchain very early on and was counsel to the Blockchain Foundation, and actually built my team for privacy with a Dogecoin team. If anybody knows what Dogecoin is, you have to be super nerdy. But anyway, I think it's come a long way. When I became Chief Privacy Officer at Amex, people were like, that's a thing? And now, really, ability to use data is so fundamental to the business model and revenue projections that the space has really changed, and I think more people are being drawn into it, not just because it's an exciting area and a good career move, but because people feel very strongly like we're at an inflection point in time where technology has created issues for us. We've created issues, and they're really difficult. It's not very clean cut how to solve them. And so I think it's a great area to be involved in. There's a lot of opportunities, but also I think it's important to get involved because we live in dangerous times, and it's an important thing the right to privacy is a fundamental right, and we should protect it.
I'm just picturing that Shibu Inu and the Dodge going
Yeah.
there. Handy. Rachel?
Sure. Good evening, everybody. My name is Rachel Vargo. I am corporate counsel with Ultimate Software, and I'm a 2011 graduate of Washington and Lee University School of Law. So I'm more on the in-house side. I work for a software tech company, like you were saying. Ultimate Software is a human capital management software as a solution, software as a service company. So HRIS. So we deal with a lot of data day in and day out, both internally on our corporate side, but even more so for our customers, where we're handling millions of HR records and all kinds of personal data for customers, and we need to make sure and work closely with privacy and security in our various teams to make sure that our product enables our customers to be compliant. And that's kind of where there was a natural evolution, and that's how I got involved. I do a lot of our commercial contract work, both on the customer side and on the vendor side, and naturally discussions of what data is involved, where is this data going, what's being done with this data come up. And as part of those discussions, and with things like GDPR coming into effect and other, kind of more publicity around the issues of data privacy and data security, I have become very closely involved with our product team and with our privacy and security teams, and providing input and counsel from the legal side on those matters.
Hi, my name is Anna Rodowski. I am a 2013 grad. I actually got into privacy by a happy accident at Brooklyn Law School. One of my friends told me to take privacy instead of tax law. So that's how I
Good move.
started. And I, did well in the course. I was an RA for the professor, and then did a series of internships in the space. This is nothing against tax law, by the way. I'm sure those attorneys are very useful as well. But yeah, so then started out of law school actually at JP Morgan on their privacy team, and then moved to a law firm a couple years ago. So I'm at Norton Rose Fulbright. I'm in their data protection and privacy team. We are kind of a jack of all trades. We're a huge firm of 4,000 lawyers, so we do a lot of massive institutional privacy projects. So we've got, lawyers all over the world, which is great because we get a great handle on data as it moves, not just in and out of a company, but throughout all of your offices around the world. And as everyone on this panel could tell you, there are very different attitudes around the world on how you handle data and what's valued by the country in which you're operating in. China is a big emphasis on national security and having access. Europe is a big emphasis on privacy. And the US is a bit more of a commercial-focused jurisdiction. So we do a lot with that, especially worldwide rollout of products. But now my practice, I would say, coming off of GDPR is still a bit advisory, a bit transactional, and a bit of data breach, as I'm sure a lot of you know is unpredictable. So I'll stop there. But
Thanks, Anna. So we have a diversity of experience across the panel, and I want to take that and start by discussing the parameters of what are we talking about here? We're talking about product development. I mentioned the term product counseling, and we have to think about, the audience has probably heard of the term corporate counsel. That's probably the most common in-house term that you hear. But when we're thinking about product counseling, what are we thinking about? Farah, do you have thoughts on that?
Sure. I will start with my legal disclaimer that these are my personal thoughts and don't reflect any of the opinions or work at Colgate-Palmolive.
We'll apply that across the board for everybody. Thank you.
And one thing I should say in part of my journey was I was in Professor Askin's clinic, and he really was pioneering the notion of Lawyer 2.0, which I think is going outside of the siloed legal department that writes legal memos and actually being interactive. So I think when I think of the concept of product, it's actually what is the deliverable. So that can be something internally to improve the workforce or the way things are run at the company, or it can be the actual thing that's being monetized and sold. And I think marketing is a huge area where there are a lot of different types of products and different ways to reach different audiences and consumers. There's platforms like Facebook where that is a product in and of itself, and then increasingly there are things like IoT devices, like I mentioned, the connected toothbrush or your Fitbit, or things of that nature. So the question was, what is a product? I think that is what I would say a product is. And in terms of being a product attorney, for me, what I've liked and what that really has focused on is being interdisciplinary and cross-functional. I work very rarely with only a lawyer. It's being embedded in your engineering teams. It's talking to your business teams about what the use cases of what they're trying to do, and really just being, a lot of times, the only connecting thread end to end from when something is being designed to when it's passing regulatory muster to how it's actually interfacing with the end user. And to me, that's kind of having that whole end-to-end system is what product counseling is.
Yeah, I mean, that makes a lot of sense to me, the idea of being sort of end-to-end from the inception of the product to actually shipping it and landing the product. And this is something you're hearing more and more about over time. And, you know, Andy, you've been in this space for quite a while. I remember when I was a fledgling law student and we were grabbing coffee and you told me, this thing has legs, this privacy product development thing.
Get into privacy.
This is an area that you should do. How have you seen it change over time, over the last, 10 years? I think there was a time where lawyers thought, can you make a living in privacy doing products? And now it just seems ever present, for all companies. How has it evolved over time, and how has your involvement evolved over time?
It's, I think it's become so central to the user experience, and my practice has evolved that I'm sort of quasi-lawyer, I don't know, like consultant, fixer, whatever. And again, I think it requires looking holistically. If you've got a product, you're thinking about fraud, you're thinking about the user experience, you're thinking about what their expectations are and what you're doing with the data and how. And privacy has gone from a consideration, and then I think when I became chief privacy officer, I think it was still very much a figurehead position, like let's put somebody nice there and don't make too much trouble. Amex is an amazing company and very reputable. But I think a little bit slow to make the turn on some technology. And I think that there's generational shifts in privacy. I'm a believer. I set out to build a company to make privacy cool with young people. Because I thought if I built something that was tuned for my age person's UX expectations, then it'd be an okay company, but it wouldn't really make a big change. But actually, I believe that young people care more about privacy than older people, and that they see it as control, and they're more adept at using digital control. And so I think that there's a shift taking place, that the people who are driving sort of the digital agenda and digital transformation actually do care about privacy. They also, it's complicated, care about personalized services and all those other things. So it's but the GDPR really registered on senior management radar because it became a line item for cost. And so I think that's a big change. The space is really dynamic.
Now, Rachel, Andy mentions this idea of sort of the young folks and the digital natives, and we see people now. You see children, infants at times playing with tablets, and it's just getting more and more complex. Yet younger and younger people understand this stuff. And in an in-house environment, you're dealing with folks that have just such a higher level of technical fluency than most lawyers have. But you absolutely need to understand the technology in order to counsel competently on issues like GDPR. How do you go about that in an in-house environment, trying to work with teams and develop enough of a baseline technical fluency to be able to give legal advice on these ever increasingly complex topics?
Yeah, I think that's always a challenge, and it's something that's important, that you develop a rapport with your business team, with your technical team. And what I tend to do is I go in and I tell them, guys, I'm not the technical expert. I know that. So please help me understand. I'm going to ask you questions that are going to seem elementary to you, but they're important that I understand and have that foundation so that I can give you the right advice and the right counsel. And I think they appreciate that. They understand that I may have the legal expertise, but they have the technical expertise, and together we can get the right mix of expertise to make the product that we want to make a product that has the right compliance elements built into it, but also is something that our customers want to use and is easy to use and is user-friendly. So it's really going in there and partnering with them and saying, you know, I know that you are the expert at what you do, and I am the expert to whatever extent at what I do, and working together and having them help me understand so that I can help them.
Yeah. Yeah, and I know from my experience, I mean, that is novel for some people, right? Lawyers in certain companies, maybe at bigger, newer companies, it is always been a part of the process to have lawyers involved in product development. But there are certainly companies where lawyers have been regarded as the folks that, you know, are the last checkbox and they're the impediment to shipping the product. So there's obviously a lot to it to building that rapport. And speaking to building to that rapport, so, you know, on a lot of different types of law, you can practice and you can show the value of an attorney by sort of showing tangibly what you got done, right? So you can close the deal, you know, you can win the litigation. But a lot of times when we're talking about products or privacy, it's really the absence of anything, right? It's the ability to say, like, yeah, I was involved in this and the FTC didn't come in and shut us down. I was involved in this and there wasn't a data breach. So specifically for somebody that is coming from outside counsel, that is charging for her expertise, how do you work with clients to show the day-to-day value of what you add to their organization?
Yeah, and we were having this conversation a couple of days ago is, you know, my partner always says, you know, we're in a position where we have to show value when, like, the success is nothing happens. So, you know, I think a lot of it is if you work with the same clients for a long time, they trust you to the point that we interact directly with the business for a lot of our clients. But also you just, like, you can't say no all the time. You have to make sure that when you're going to say no to something or something is, like, not okay with privacy laws, you're coming back with, this is how we could do it. I have an idea that we could do it this way. Do you need that data? You know, you're a cooking app. Do you really need to get their location? So, you know, we try to think critically about, like, what is it they want to do and how can we help them do it in a way that works for them. I think the other thing that's become a huge emphasis is regulatory strategy up front. We work with a couple companies now that have recognized the importance of, especially when you're capturing data, if that capture point is not compliant, you are in a lot of trouble on the back end with that data. You're in a position where you can't use it because you didn't collect it correctly. You may have to go back and reconsent or get authorization to collect the data again. So we have really been putting an emphasis on, one, do this right to start. Regulatory strategy is part of your business. It's part of your getting to market faster. It's part of growing internationally faster, that there is a benefit and there is a monetary benefit specifically to a regulatory investment up front. And so we've been really making that pitch to our clients. And I think it's actually been landing really well with tech teams, marketing teams who are like, oh, I could expand in China faster if I get this right now. So that's, I think, a lot of it is, but that's not a traditional lawyer mode. That is I have a business hat and I'm gonna help you sell your product or offer it in different jurisdictions faster.
Yeah, it makes a lot of sense to me there, what you talk about, you know, the catch point of the data, because again, if that data is sort of sullied from the beginning, and especially if we're talking about data that's going to go into your overall stack, and then, you know, what are you going to do if you're commingling that with everything else? You have some issues there. So
Yeah.
not that I have any professional experience with something going wrong from the beginning and then causing lots of problems, but it's certainly something that you have to be cognizant of as you're designing things, right?
And the more complex your data sets get, the harder it gets to pull them apart, which is one of the problems with GDPR, where you have to kind of go looking for a data subject's data. But when you're making a complex data set, or when you're talking about unstructured data or dark data, once it's in those states, like, good luck finding it, like, or isolating what you need that hasn't been collected right. That is an operational challenge that is still being tackled, I think, by everyone who is subject to GDPR.
Yeah. So let's dive a little bit more into that. So Rachel touched upon this a little bit, Far, but when you and I were talking about this, you put it pretty succinctly. You put it as practice, not paper, right? This idea that in a lot of other situations, like we papered the agreement and, there are certain indemnities in there. I'm like, go ahead, put it in a drawer somewhere, and if something goes wrong, then, we'll pull it out there. But if we're talking about something like GDPR compliance, COPPA compliance, VPPA compliance, you can't just put something on paper and then say, okay, we'll take a look at it when something goes wrong. You really have to get your hands dirty working with the product people and the engineering people to make sure what you've put on paper actually happens in operation. How do you start that process, without going too deep into anything specific at your company? Like, what is your general approach to, we have some new product or data flow or something like that, and I need to make sure that on the back end, the reality reflects what's on paper?
So I think a lot of it is, when do you get engaged? So I've worked at 2 different companies, and then I've also worked at the government, and I think part of it is, if you are, again, engaged early on, you can show your value add, and you can just map up from the front. These are the things I need to know. I need to know the data flow from how we're collecting it, where it's being stored, who's sharing it, how we're going to use it, how long we're going to keep it for. And I think that's kind of the best case scenario when you're there at the beginning. If you're dealing with something that's already been developed, or you're trying to retrofit or modernize something, then I think it gets trickier. But the best thing to do is just lay out, you need to understand what is happening. I think what Rachel said is really true, where it's, you have to understand the product and what's happening. And as you do that, I think one of the things that I've seen a lot is, there are very rarely first of all, I think most things have some element of data in them today, just by the nature of the way the world works. And very few products are completely solely developed by your company or organization. There's a vendor who does payment processing. There's a vendor that might host the back end. And so it's being able to identify what are all those touch points, and making sure you check what are their privacy policies, what is in the contract with that user, and then how do we anticipate the product working, and all of those touch points, does it line up? And if it doesn't, knowing that you have to go back and figure that out. Because I think one of the points that people who may not practice in this may not know is, especially in the US, what you put on paper and what you represent in your privacy policy is what you're going to be held to and taken to task for at the FTC. So if you write something on paper that sounds great and amazing and perfect, that's going to have you dead in the water if you're not actually doing that.
Yeah, it makes sense, and I think you're probably seeing a lot more transparency too, because in the U.S. in the domestic context, it's often been your publicly facing privacy policy, and the FTC might take you to task there if you're not reflecting that. But you're probably seeing now more, certainly under GDPR, of this transparency, right? Data protection impact assessments, DPIAs, need to be available to your primary regulator, and this is a pretty detailed document of exactly what you were talking about there, how it works on the back end. So you're talking about a higher level of scrutiny. So it has to be, very, very important in your process to actually get involved with folks and make sure the practice, as you say, reflects the paper. Now, I know certainly at my company there are major, major implications with regulators and others if the practice doesn't reflect the paper. But I wonder at smaller, medium-sized companies, and Andy, you've had visibility into this, so thinking about folks perhaps who are looking to exit, to be involved in a corporate transaction, and you are seeing now sort of a changing landscape. It used to be, is your cap table all right? You have any environmental liabilities? But now we're seeing, there's the Harvey Weinstein clause has made it into some merger agreements. I'm sure there are things in all the big firm templates now in the merger agreements about data breaches. What are you seeing on the M&A front, on the corporate transaction front? Is privacy actually something that's moving the needle?
So I shifted my practice to probably 50-50 doing corporate transactions and doing a lot of diligence and repeat diligence for certain companies and banks, because I just find it interesting. And so doing IPOs, secondary offerings, and all different types of transactions. The approach I come from, when I was at Amex, I helped collapse privacy and security into operational risk management at a time that American Express became a bank holding company subject to FDIC oversight and things like that. And I think what that does is it puts ownership on the business to design and support a sustainable process. And then the subject matter experts, like the lawyer, have to provide very clear criteria that is going to be measured against. I think the benefit of a big company like Facebook, hypothetically, but a tech company like that, is that they're used to designing high integrity processes and auditing them and things like that. At an earlier stage, I think, for me, I think that I think these are important issues, not just for legal regulatory, but for risk management and running a business. So no matter what size company, I'm going to say you need a very strong privacy policy in terms of use. And then internally, you need a written information security policy, a vendor security management policy, and incident response policy. I've basically given these policies away. What's very interesting is a lot of the VCs don't have great corporate governance on risk management. So they've been leaning on, so it's working its way through the ecosystem. I think that no matter what size company you are, you have to treat this as core operational issue.
Yeah, it makes sense. No, Rachel, I mean, I think it's easy for Andy to bring down the hammer on his clients, right? He is the partner, the storied partner, you know, at a big law firm, and people, you know, understand, you know, that they're you know, paying for his time, and like they should listen to what he has to say. But as in-house counsel, I mean, we face this challenge of we're just another employee on the org chart, and you know, as we're interacting with people, we might not bring the credibility to the table sometimes that they're looking for. So as you're counseling internally, how do you sell the value, whether it's to the constituents that are actually putting this into place, so the product managers, the engineers, the business folks, or maybe even up the chain to the C-suite when you need resources, or when, you know, as Farah points out, right, from the beginning, it's easy enough to build these processes into place. But there might be times where you have to back out of something, and that requires some real operational costs if you say, we actually have done it wrong. We need to take a couple of steps back, and we need to try this again. How do you get that buy-in? How do you get that credibility?
I think the key to that is partnering with the business from the beginning. And in my company, fortunately, we have a culture of an entrepreneurial kind of spirit, and we all have the same goal of bettering our product and providing the best product we can to our customers. So I think partnering with the business, like Anna was saying earlier, if you're going to say no to something, if you have to say no to something, if you have to say we need to redo this, it's also being solution oriented and saying, but here are some ideas of how we can, or here are some additional questions I have that will help me work with you to figure out what we can do and provide some parameters. I think that's the key in terms of in-house, is really partnering. You don't want to, and we really try hard not to be a roadblock to our business, to our product developers, but to also get them to understand and work closely with legal and privacy and security to understand that doing it right from the beginning will save them a lot of headaches in the end. Will save them time redoing or undoing or trying to find a new way to do something because it wasn't done the right way from the beginning. So it's really building that partnership.
Makes sense. And I have this sticker that I got at a privacy conference, at an IAPP conference, and it says, "Data is the new currency." They were handing these out like candy. They thought that it was pretty cool, and I think there's a lot of truth to that, right? Like if you have big data, you can find all of these new ways to monetize big data. But you know, as Andy said at the beginning, right? Privacy is a fundamental right, and we need to make sure that like we're not just, you know, leaving big stores of personal information hanging around, because certainly for the folks that we're you know, counseling, that could be a big risk. So how do you, from the outside, try to influence the business plans, the governance within an organization, to be able to say, just as Rachel was just commenting on, I know you need to make business, you need to make money, you need to keep the lights on, but I want to draw a line somewhere in the sand that you shouldn't be just keeping data for data's sake, because there's some real financial risk to that.
Yeah, so I think the first thing is I'm trying to move away from the term big data, because I think it's actually a really bad idea to just collect everything and save everything forever. And I think there was a mentality for a while that was, you know, we're going to collect all of this data, and this can be potentially a source of, you know, this could be a revenue stream once we figure out how to use it. I think a couple of high-profile data breaches, incidents, just like misuse of data have sort of pointed to the fact that collecting everything and saving everything isn't a great idea. So we've kind of moved towards, you know, let's think about smart data. What is the data that's going to work for you? What is the data that you can monetize, as like kind of an icky of a word that is? But like, what is it that your business is trying to do, or what your product is trying to do, and like, what is the data that you need? So if we're looking at someone, you know, in a clinical research space, you know, you don't want to necessarily collect everything unless you have a reason to, or Do you have a target? Why are we collecting, all of these things that are not, family status or anything that's not related to what you need? We really push the business to think critically about what they're doing, what they want to accomplish, and how data fits into that. So we're pushing, it's kind of big data 2.0 or smart data. So I think that's the first part. And then the second part is once you decide that you're not going to use that data or you're not going to sell that data, is thinking really carefully about getting rid of it. It's amazing how many companies don't have retention policies or really deletion policies. I was working with one client recently, and I was reading emails and data stores from 1994. And they had no use. They were in a format that I've never seen before. Yeah, essentially. And we're like, well, why do you have this? And they're like, well, we save everything forever. And we're like, well, let's think about that.
It's like an episode of Corporate Hoarders.
Yeah.
Of some sort.
And it probably was off a floppy disk. But it was just, and the other thing about this is all of this data, when it's in different formats or it's in different sets, you can't actually merge it together. So that's another thing that you have to think about is like, if you have all of these systems that don't talk to each other, and you have 3 systems that you've essentially entirely decommissioned and are not in use, and there's no plans to use them, and you know that you have a ton of data sitting on them, we'll be like, figure out how to use it. Let's figure out a way to use it, or make it, put it into a format that you can use. And if that's impossible or you're never going to do it, let's think about getting rid of it. So I think that's a big part of it too, is use what you need, get rid of what you don't need.
It's a logical approach, and you have to draw that line somewhere. And I think sometimes just asking the question, there have been a lot of times where I've asked product people, well, why do you need to keep this? And it all kind of goes quiet for a second, and they're like, well, I don't know that I actually gave that any thought. And sometimes just asking the question forces the discussion. And you'll often find, with data, certainly on my side of things, with advertising and things of that nature, data goes stale. So, we're humans. Our behaviors change, our aspirations change, our purchasing decisions change over time. So I think, a big element of what we do is really pushing people for the practical and saying, I know that you want to preserve optionality here, but that comes with increased risk. So really think logically about what we're going to use this data. Now, Farah, I said I wasn't going to pick on you, so I'm going to make sure I'll flip the tables here. So I work for a company where the average age of the employee is probably teetering around maybe under 30 years old. So everybody is sort of brand new to this game and is up for whatever we need to do in terms of implementing privacy and process, and they want to do that. On the other hand, you work for a CPG company that's been around for a while.
Over 200 years.
Over 200 years, okay? Before, Warren and Brandeis did, the right to be forgotten, to be let alone, or whatever that first, law review article was. So how do you find some of the things that we're talking about here, this idea of, inserting yourself into the process and, finding the amount of data that you have to keep? Is this something where you're finding that you have sort of carte blanche to make the calls on because folks are sort of not familiar with what's going on, or are you finding a little bit more resistance because they want to do things as we've been doing them for the past 200 years?
I would say in an organization of Colgate size, it's dynamic, right? It depends on the team, it depends on what they do. So I think there are some areas that are really receptive. There are some that just don't understand, to Anna's point, they have data where they don't even know why they have it. And I don't think that's unique to either organization I worked at. I will touch a point on one of the things, I think one of my greatest victories as a product counseling attorney was at one of the organizations, I had an engineer send me an email, is it okay if we stop collecting this data point? And I was like, this is great. I officially, that team has went over, they understand it, they're like, we're not doing anything with it, we don't need to collect it from that product anymore. So I think one of the big things at companies that are new to the game, and I think this is also a huge thing that I would think back to my Blip time when you're talking about with startups, is just having them actually think about it and ask that question, because there's a huge educational component. It's not as embedded in the DNA of the company to think about these questions or to ask, what data do we have, why do we have it, what do we need to use it? And I will say one of the things that I've seen a lot is with older, larger companies, they're trying to innovate. Everyone is trying to be involved in the tech space, in the IoT space, and have a foot in that game. And a lot of the ways that companies do that is by trying to do M&As or partner with startups. And I think one thing that would be critical from all of the attorneys here, a lot are going to work at startups, is to embed that culture of product counseling and privacy and thinking about data retention. When I talked about end-to-end, I think one of those questions should be, how long are you going to keep this data? In what format do you want to keep it? Can you keep some data points? Can you anonymize it? And having that be ingrained in how we as lawyers counsel our teams and our companies for whatever stage they are, I think will do a lot to move that needle forward.
Andy, you probably have a very diverse slate of clients. So you're talking to the big guys, you're talking to maybe some of the upstarts that are growing quickly. Is there a difference? I mean, when we're thinking about the way that we counsel on products, when we're thinking about data, when we're thinking about privacy, should Farr's company, should my company think about data in a very different way than the 10-person startup that just had a hit on the App Store and is growing rapidly, but 4% of GDPR, 4% of revenues if they violated GDPR would be nothing because they're not making any money at this point. How do you approach these different situations?
Yeah, this is like, I treat them all the same. I think that you do these things because they're part of the business. And I find that I do a ton of work with early stage, but they tend to be serial entrepreneurs or people who are coming through systems and work with the right partners. And, you have to earn your stripes as a lawyer. So one of the issues that you have to raise with any company that's starting is, what are you doing about anonymizing and de-identifying data? I mean, that's really helpful for Silicon Valley companies to be able to hash and salt and, have a statistically sound methodology for creating segmentation and things like that. And so I think the startups are very receptive to it, and they get it, that when they create the disclosure that you guys said is your contract with everyone out there that the FTC and the AGs are going to judge you by, that it reflects your practices. One of those issues is, have you said anything about whether you're going to use de-identified or anonymized data? And so I agree that data destruction is super important, data minimization, but also there's a lot that you can enable companies and marketing teams to do. And what happens sort of in the growth of companies is seed, Series A, even Series B, they're cranking and growing on the core product. And then later stages pre-IPO, they're thinking, what other revenue streams do we have? And then it's like, well, we got all this data, we have all these unique insights into our customers, and so at that point it's very hard to backtrack, change disclosures, change contracts with partners. So thinking prospectively about those issues becomes really critical to the ultimate growth of the company.
Good. I'm glad the 10-person startup has to do the same stuff that I have to do. That makes me feel better.
The Article 30 registry is considerably smaller.
That's absolutely right. I'll keep the records. They can get away without that. Rachel, what's keeping you up at night? What is the things that you are seeing more consistently within your organization that are posing challenges, either because they're just generally hairy issues? I have to imagine GDPR generally is probably on the top of this list, but things maybe that are just tough to deal with within the structure of the organization because you have to draw sort of, at times, almost an arbitrary line between monetization and data privacy.
Yeah, I think one of the things that is the most challenging lately is because of things like GDPR, which have such a broad scope and such a broad applicability, customers have become a lot savvier. We're a B2B company. Our customers have become a lot savvier about data privacy and data security. They may not be well versed in it, but they know about GDPR now. They know they want a DPA. They know that they need to be able to do X, Y, and Z with our product. So it's customer awareness, I think, consumer awareness of these issues, and then them asking the questions and us being able to respond and say, we have updated our product to be compliant with GDPR, to enable you to be compliant with GDPR, and that was a big project for us, but an important one, not only from a compliance perspective, but also from a customer service perspective. Our customers need to be able to do that, and they expect us to enable them to do that.
One of the big drivers of compliance with GDPR were vendors whose clients were saying that they need to be compliant.
Exactly. And I think that's always the case. I think GDPR is something that's made it even more at the forefront for our customers. And something that, we always have built into our product compliance, and we have an entire privacy and product compliance team that works on that day in and day out. But I think the customer awareness of it and the external consumer awareness of these issues and concepts, even if they're not particularly well versed, they're aware of it now, and they expect you as the tech company, as the one providing them with the product, to have the answers for them.
I love that years from now we'll say that GDPR was the thing that made privacy cool. Everyone now knows that they have to pay attention to it. People that aren't even in the industry knows what GDPR stands
I'm
for.
told that GDPR outpaced Beyonce in searches on Google one day. I don't know.
Not
that.
my Google searches. And I am no stranger to having to explain why big data. Sorry, I won't say that. Why data practices are not creepy. I spend about half of every meal that I have with my mother-in-law telling her why she shouldn't be afraid of the internet and what some of the big companies are doing out there. And I understand her concerns because a lot of this is tough to understand. But I think one thing that we need to maybe not grace over is the fact that there's a lot of good that can come from data. And I know you and I were talking about this, and there's a specific example of assisted reproductive technologies that you've been looking into where good can come from the use of data. You want to tell us a little bit about that?
Yeah, so one of my interests in sort of that's emerged over the last 6 months of the last year, and I've been doing research on and doing work for some clients on, is the use of data in both research on people who are pregnant and then research on people using assisted reproductive technologies. Pharma companies and most companies have stayed away from pregnant people for obvious reasons. Doing research on them obviously raises a lot of ethical concerns, so it hasn't been done. So to date, there are only about 8 or 9 drugs that are actually approved by the FDA for use in pregnancy. And so a couple of companies and apps have moved into the space that are saying, people who are pregnant are taking drugs anyway, but they're doing essentially a clinical study of one person. Doctors have to treat patients, and they're kind of guessing. And that's actually kind of scary. And so we've been really focusing on how do we create programs that people who are actually doing this anyway can centralize their data and their findings and what's happening. The goal, and the FDA is running a program now, is they want to up the number of drugs that are approved for use in pregnancy. And the actual term for pregnant persons in the clinical context is clinical orphans, because there's just no data on it. There's really bad research on a whole bunch of things. Bed rest has no clinical significance, yet something like 75% of all doctors still recommend it. So data here can unlock not just huge benefits in terms of a company perspective. There's a huge upside to patients and people trying to start families, because right now there's really no regulation of reproductive technologies. So it's kind of like the Wild West. It's a per state basis, what they're collecting, what they're saving. And then the other thing that we worry about always is people who are sort of entering use of reproductive technologies are always kind of in a vulnerable position, and they're giving up a lot of rights to their data, to their tissue samples, maybe without knowing it. And so we're trying to focus on that space, focus on essentially a space that's been neglected since its existence.
That reminds me of the recent, there was 23andMe, the genetic testing group, had some agreement with a pharma company to try to give some of their data over to the pharma company so that they could come up with drugs based on the percentage of people that have different potentials for diseases. And it's such an area that is rife for improvement of lives, but obviously is also rife for some privacy invasion too. So it's something that we need to be very careful with.
Yeah, and it's a lot of people don't know this, but a lot of rare diseases are exempted from certain privacy laws. So there are, at least for researchers, freer use of the data just because it's impossible to anonymize. You're usually dealing with a family, especially in the case of a genetic disease. So knowing one person means you might know everyone with the disease state. And a lot of people who, if you're really sick, you're vulnerable. You're not really in a position to be thinking about what sort of rights you're giving up and where your data is going to be used and shared. And so creating, I think, more transparency there. I mean, there's a lot of benefits to using that data, but I think creating more transparency baked into that system is really important for patients.
So I want to save time for one more question that I have for the panelists, but I also want to open it up now to the audience for you all to ask us questions. So I think we're probably in a small enough room that we don't need mics here. So if you want to just or I think we may have mics here. So if you want to just throw up your hand and I can point to you so we don't have too many people at once. But please, you've heard the amount of collective expertise on this panel. Please pepper us with as many questions as you might have. Sir, over here. You want to grab a mic real quick? Thank you.
So you guys operate in different areas and whatnot. What do you think regulators are missing? Like, where are there gaps? Andy, I mean, in particular, you're talking about it being a fundamental right. You know, Google, Facebook, and others are pushing Congress right now to preempt what California just passed. So, I mean, are there any thoughts towards, you know, where there are gaps right now in regulation? Where could we be more thoughtful? And the second quick part of this is some of these contracts and, you know.
That first one was a big one.
I think you have an internship with the FTC, too. I think
The quick question would be, you know, do you feel like some of these contracts are adhesion contracts where, you know, you click yes, but you have no idea? And can this be simplified, especially depending on how important the data is that you're giving up?
Couple things. One is that in Europe, privacy is a fundamental right. And probably the greatest accomplishment of GDPR was creating an accountability framework. And so I've been saying recently that I think that the two strongest regulators of Silicon Valley, number one strongest, engineers, young nerds. They drive the agenda, believe it or not, at the top tech companies because you need those folks to keep developing technology. And the minute a company starts to go in the wrong direction, they pile into the next thing. Second one is Europe, and GDPR established the same kind of accountability framework that antitrust has, competition. And actually, the competition law commissioners in Europe started hiring privacy and data protection experts, and the first action they brought against Amazon was for antitrust related to misuse of data. And so actually these privacy issues are bleeding to other things. The challenge we have in the US, California passed CCPA. It's likely to kick off a domino effect of other state laws. Now a lot of tech companies are saying, okay, now we're sort of into a federal privacy standard. The tricky thing is, where do you put it? And so we don't have an omnibus sort of privacy law the way Europe does. And so I think it's probably going to take a while to get something done at the federal level. I think the states will start to drive the agenda, especially with state AGs that are politically motivated. And however, I think Europe is going to become very active, and I think the intersection of antitrust and privacy is going to happen in the US as well. That people are going to start to look at, you know, maybe it's not just traditional anti-competitive behavior, maybe it relates to how they use data or serve up advertising or have metrics. The other thing is, I also believe in free market economy. That's why I founded privacy.com. I think people will start baking privacy into their products, and certainly mature companies that are looking for additional revenue, they're not going to find it with more users unless we like go to the moon. And so it has to be developing deeper, more meaningful engagement with the users they have, and I think that there will be new companies where privacy is a central feature of the product and becomes a competitive advantage, hopefully.
I'll layer onto it a little bit and you know, make sure that my personal beliefs here don't conflict too much with my, you know, professional duties. But I think one thing that's important to think about here is absolutely that there are certain jurisdictions where, you know, privacy is considered to be a fundamental right based on their history, and you know, maybe over time that belief is becoming the dominant one worldwide. I think we should be smart about what kind of data we're talking about, right? We've been talking about data up here as though it were just sort of one class of things. And I don't know that that's the case, right? Like, I am much more concerned about my health data and how that is used. I am much more, and if we break apart both the collection and type of data and also the uses of data, you know, I am much more concerned about how my data is used for things like credit eligibility, how it is used for, insurance and whether, I can live in a place than I am as to whether, my data for, looking for a new fresh pair of Nike Air Maxes influences the ads that I see on Instagram the next day. So I do think that we need to consider when we're thinking about privacy, sort of the tranches of what are we particularly concerned about, and the fact that, Equifax happened, and then we sort of just like moved on because it wasn't sexy to like talk about Equifax, was puzzling to me. But I certainly think to the points that Andy made and to your initial question that the tsunami is coming, and Congress is not that effective. But when you can get behind something, anytime that they have a law where there's nothing objectionable in the name of the law, right? The Omnibus Act to get everybody a puppy and ensure their privacy from people that don't want to be involved with, like anything that is going to be uniformly supported certainly is something that could come through. I think it's just a question of making sure that it's tailored properly so that it doesn't undermine some of the things that we already take for granted, things like free content, things like personalized experiences, and that you just find that balance, and you certainly think about the way that you can communicate with your users such that you can allow them to find that balance and make choices on their own, potentially. I had a question over here. Oh, I'm so sorry.
I'm just going to jump in quickly. One thing in terms of what the regulators are missing, I think part of it is the same thing that as a product counsel you do. You need to understand the technology. So I think some of these testimonies, some of these more interactions between corporations and regulators is really important. There's also different industry groups that are trying to do that education in Europe. That was a lot of part of the movement in Asia that's growing. So I think regulators also need to understand what the technology is to be able to regulate it. But where product counsel is always going to be at the forefront is the law is always going to be behind tech. So you as a product counsel can help influence and safeguard that because you're going to develop that before the law gets there. And I agree with Andrew's point, but one thing I would just say as a counterpoint, as a product counsel, what you have to do is think about what is the potential misuse. So your business interest is using the data for this way. What would a hacker use it? How would someone who just had a nefarious desire potentially be able to use that data? And for some of the home IoT devices, they've been misused in a domestic violence context where people who have an abuser then have had their devices hacked and just kind of the lights going off and things like that that will torment them. So from a product counsel perspective, is that what your business team wants to do with it? No. But what can you do to build in safeguards and security so that it isn't misused?
That's why I threw Alexa in the garbage. Sir.
Well, this is a very good topic. Oh, hi. Thank you. This is a great topic, but we've been focused, or your answers have been focused on U.S. and European rules, U.S. being much more lax on privacy than the new European rules. How do you address China, which is sucking up information at a rate many times that of anyone in the U.S., including the NSA, and they're taking some of that data to look at, to rate their citizens as to their political views. I've read stories of people who suddenly can't get on an airplane, Chinese citizens who suddenly can't get on an airplane, or their credit is suddenly declined because the Chinese government in their data collection found that the political views of the individual have been not in sync with the government. How do you deal with that? And I am concerned that a country like China will export that in the following manner. I'm making this up as I go along. A plumber in Columbus, Ohio, who has nothing to do with China, or at least he thought he didn't, makes a couple of comments on social media that are considered bad form by the Chinese, and suddenly his supplier of plumbing supplies is told not to do business with him. So how do you address that?
Yeah, it's a great question. I just want to make a quick connection here between the question that you had asked and something that Andy said earlier, is the idea that part of this is the responsibility of the government, but I think a lot of this is the responsibility of private enterprise, and the fact that it was about maybe 3 weeks ago, 4 weeks ago, where the New York Times covered the fact that a number of Google employees came out with a petition and basically said, hey, we heard that there's this program where you were thinking about entering.
Don't mess with the top nerds, man.
Yeah.
They're socially impactful.
The eggheads have power. And they said essentially, like, we heard that you're doing some program where you're potentially entering the market in China and agreeing to censor search results. We want transparency.
Well, wait a minute, they preceded that by 3,000 Google employees forcing Google to stop doing work with the Department of Defense. Those Google employees
But the-
live in this
but
country,
the-
and it's our Department of Defense that protects them.
I think, so it's a dystopian nightmare, what's happening, in my opinion, in China. And it's showing you how quickly they'll develop lip reading algorithms. And right now, this is all to extract data that's sort of ambient data. Soon you'll have sensors. You won't need to use a ton of machine learning. You'll just have very clear data on things. And so I think a lot of that technology will be exported. And it's dangerous. I think at one point there was a discussion, would the rest of the world go more towards the US approach of no harm, no foul, or to the European approach? And clearly, there's gravitational pull towards the European approach, so much so that there have even been like Republican senators on the Congress floor saying we should be looking to Brussels, I think they're inviting somebody from the EU to present. But I think the fundamental questions are collection. In the US, we've had a process that up until now, people can collect data and then we're gonna put the limits on how you use it. And so I think that's one of the key issues that needs to be resolved. And the consent that goes with that, should you have to give consent for people to do these things? And so I think that China, unfortunately, is rapidly accelerating their technology capabilities and fully indulging in some of the most oppressive surveillance capabilities.
And, we work really closely, I've been doing a lot of work now with our Hong Kong and Beijing offices. And it's really interesting because, a lot of our Hong Kong attorneys are, from the UK initially or from Australia, when you're talking with the Chinese, attorneys, because they're very defensive about it as well. I think it's culturally quite different from the European approach where it's a fundamental right. The US, you have a more free market. But in China, there is concern about how the data will be used, but not the way you see in other, I think, countries or even the surrounding countries. Hong Kong, Korea, Japan, they have some of the, tightest data regimes around. But in China, you're moving toward, I think, and you see attitudes that favor a strong state, a strong centralized state, and they view this as an extension of it. And China has been very aggressive about, keeping this data in China too, which I think is one of the more complicated things. China has a data localization requirement that requires essentially to keep your data in China. And the reason for that really isn't anything to do with privacy at all. And so the motivations of the government there are much different. It's not really protecting privacy at all. It's really focusing on keeping this data as part of their, they culturally maintain control over their citizens. And this is something that they, have prioritized, especially in the last, I'd say, 2 years. It's really accelerated.
So I think we have time for one more question from the audience, and then I'm going to throw in my question. Sorry, feel free to talk to us upstairs. I had a hand in the back over here earlier, so go for it.
I wanted to ask if you guys could shed some light on transitioning from being in law school or working at a law firm to finding a product or corporation, company to work with as far as the development goes.
Yeah, I think we can do that. Want me to start? You guys want to start? Yeah. Sure.
Why don't you kick it off?
So, I actually spoke with some BLS students earlier today about this, so apologies for those that were in that discussion. You'll be repeating myself here. One thing that I'll say is that this is a little bit of an untraditional path. The conversation that I was alluding to earlier that I had with Andy, I was saying, do I go to a law firm? Do I go to a typical corporate place, or do I stick with this tech product privacy thing? And some of the stuff that he said to me was find an area where you can add some value, where you can find an expertise. So one of the things that I sought out when I was at a company called Undertone before being recruited to go to Facebook was finding sort of the void. Where was there an area where nobody in the company was an expert, or at the very least had the right fluency to be able to mitigate risk? And that allowed me to be a young attorney who was looked to speak knowledgeably on a topic where other people couldn't speak knowledgeably. So, that's not necessarily a, I looked on Indeed.com type of answer, but I think it's something that you can use pretty broadly to think about wherever you are, whether it's now in an internship or if you're in a clinic or something like that. Think about the idea of where is there an area where there's a need and that need is not being filled, and I think that helps. And then the last thing I'll say there is network. You guys, a lot of the folks in the audience have the ability to use the student card, and no one's really going to say, no, I don't have 15 minutes to talk to a student who's interested in what I do. People love to talk about themselves, so feel free to reach out to people, maybe drop $4 on a latte and ask them to tell you a little bit about what they do, because maybe that doesn't lead to a job, but maybe it leads to, another coffee and another coffee, and at some point it does lead to a job. So.
Yeah, and to echo that, it's to be open. It's I went directly from law school in-house, but I wasn't working for a tech company at the time. I started off with a distribution company, but it's being open and it's learning, being a generalist sometimes first, but also finding those opportunities to develop a niche set of skills. That's kind of what me and my colleagues do as well. We're all generalists first. We're a relatively small legal department in a very busy and fast-paced company, which is exciting. But we've also all been encouraged to develop that kind of specialized skills as well, whether it be privacy or some other area. Look to see what is interesting to you and what is also a need for your company, and that you can add value to the company by, becoming kind of the expert in that. And, be open, learn as much as you can, and don't be afraid to say, I don't know, but let's go figure it out. Let me talk to the people who know. Let me, figure it out and figure it out together.
Well, I was going to ask another question, but that was just such a good one to end on that I think we should just wrap it up there. So if everyone would just take a second and thank the panelists here for their time.